was racially polarized voting even within the Democratic Party. That's where Section 2 matters, where you have a reason to think that a racial group is being treated.
Here too. You have proof of that here.
No, you don't. What you have here is that Republicans and Democrats are different. There's no.
You have some that even white Republicans or white Democrats won't vote for black candidates.
Right, but if these were white Democrats, there's no reason to think they would have a second district. None. And so what is happening here is their argument is because these Democrats happen to be black, they get a second district. If they were all white, we all agree they wouldn't get a second district.
Might have been one of the mic drop moments, but they were 2.5 hours long. Pleased to bring in Harmeet Dhillon right now, Assistant Attorney General for Civil Rights. Welcome in. It's great to see you today. What an impactful case this will be, Harmeet. We look at Louisiana, and I believe we have the map here. That was very well articulated, and you co-wrote the Justice Department's amicus brief on the case. Are you optimistic the judges will rule in favor that this is illegal?
Well, so these are complicated issues, and what happened here in the background of this case is that, first of all, Louisiana drew some maps. It had one minority-majority district, and then they got sued by the NAACP saying that there should be two. So then they drew two, and then they got sued by white plaintiffs saying that that second one was unnecessary, and in fact, the use of race in redistricting is unconstitutional. So I don't know if the court's going to go as far as that, but the United States Department of Justice position, which you just heard very ably articulated by my colleague in the Solicitor General's office down the hall from me, is that the use of race is very rarely appropriate in 2025 here in the United States. And there are circumstances in which, like in this case, we believe it violates equal protection to assume that because of how people are voting, that must be governed by race as opposed to political determinations, which are entirely appropriate in redistricting. So I'm optimistic, and of course, the Voting Rights Act is one of the important civil rights acts that I administer in the Department of Justice, and it's also something that I've dealt with in my prior life before I joined the DOJ. So it's a landmark case, and I feel optimistic that 5 or 6 justices are going to vote for a change on the Voting Rights Act.
Yeah, and your goal, and it's clearly stated, to fight that DEI, affirmative action, eradicate it from anywhere really the federal government is touching this. It seems like this is an example. You mentioned the NAACP, and they had a lawyer there as well saying, well, this is necessary because white Democrats were not voting for black candidates, whether they were Democrats or not. I want to play this exchange from yesterday.
We know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
I think a lot of people are looking at this and listening and saying, well, that doesn't sit well with Americans. Blacks for Trump, Latinos for Trump. This isn't the way, as you said, the Section 2 was really drafted. And now to have that and continue on, I think the key, too, is how this impacts the midterms. In some ways, many people think that the Democrats are trying to have it in a way that it will be, shaping how they, whether or not control the House, whether or not they impact in Congress, Harmeet.
Yeah, well, so what's interesting about Section 2 jurisprudence is it definitely was passed by Congress to remedy some historical wrongs, but we've had this case law, including this case called Jingles, that has Jingles versus Thornburg, which has put these factors in there, and they're almost exclusively racial in nature, and now it's become an entitlement. And so Ahash Mupan made a very important point yesterday, and that was that 75% of the African-American members of Congress are not elected from a special Voting Rights Act Section 2 district. In other words, Americans are perfectly capable and regularly do vote for African-American candidates without the assist of racial gerrymandering. And I think its time has come and gone for the most part. I suppose theoretically there could be a case where it's necessary, but in today's America, people are getting elected throughout the South from both parties who are African-American, and that's wonderful, and that's our country. And you look at black senators are being elected statewide in majority white states. So, I think it's time to move away from this and really have people make their case in the political sphere, not in the courts.